Hi guys, welcome back. No matter where you are in this fight, it helps to know that our judges are bound by a set of legal standards and rules that are set by the Supreme Court through the case law. Whatever task we're trying to do, it helps to know what those legal standards are and to be able to cite the cases that they came from. Knowing that is going to give us an idea of what our judge should and shouldn't be doing at whatever stage of the process we're at. And knowing that stuff is especially beneficial at summary judgment, where so many of us lose our cases. Last week I shared a template that I created to help those of you who don't have an attorney at summary judgment start drafting your oppositions. And in that template, I referenced a lot of legal standards and case law that I really didn't have time to go into. So today I want to share a few legal standards that I think every plaintiff should know at summary judgment, talk about the case law that created those standards, and share some examples that show you how to cite that case law along with your evidence to strengthen your opposition. Now, even if you don't have to draft your own opposition, today's information should help you guys understand the process a lot better. Now, the most important standard to know is the summary judgment standard. It tells us that summary judgment is only proper when there's no genuine dispute about any material fact and the moving party is entitled to judgment as a matter of law. Now, this standard is implied in Rule 56 of the Federal Rules of Civil Procedure, and it's been reinforced by the Supreme Court in the case of Anderson versus Liberty Lobby. That says that the mere existence of a factual dispute between us and our employer won't defeat an otherwise properly supported motion. But if that dispute is over a material fact, meaning a fact that might affect the outcome of our case, that might be enough to defeat an employer's motion. So what we're trying to accomplish in our opposition is mostly to find those genuine disputes of material fact and point them out with evidence. So if your employer says they fired you because you were late, and you have records that show you weren't late, that's a genuine dispute of material fact that you definitely want to bring out in your opposition. And here's an example of what that looks like. The defendant claims plaintiff was terminated for attendance issues, but plaintiff's time records, Exhibit 3, show no such problems, creating a genuine dispute of material fact that must be resolved by a jury, not on summary judgment. Next comes the favorable inference standard, which says that at summary judgment, our judge is supposed to interpret all the facts in the light that's most favorable to the non-moving party. And when we're writing an opposition, that's us. Now, this standard also comes from the Anderson case, which says that at this stage, our judge is supposed to believe our evidence and draw all justifiable inferences in our favor. So if our supervisor did something like make a bunch of vaguely discriminatory comments and later try to claim that they didn't intend them to be discriminatory, we can point to evidence that shows otherwise. And that evidence could actually be a sworn statement that we prepared. And at summary judgment, the favorable inferences standard tells our judge that they have to believe our version of the facts and give us the benefit of the doubt. They can't just decide to believe our supervisor over us. Plaintiff's sworn statement, Exhibit 5, describes discriminatory remarks made by the supervisor, which must be accepted as true and viewed in the plaintiff's favor at summary judgment. And then we can cite Anderson. This next standard says that at summary judgment, our judge shouldn't be doing things like weighing evidence to determine whose case is stronger or determining credibility. And this standard comes from the case of Anderson as well. Credibility determinations, the weighing of evidence, and the drawing of legitimate inferences from the facts are jury functions. So for instance, in situations where our sworn statement conflicts with the sworn statement of another witness, we can cite this standard to remind our judge that that creates a credibility issue that can't be decided at summary judgment. It has to be decided at a trial. Plaintiff's sworn affidavit, Exhibit 2, directly contradicts defendant's witnesses, creating a credibility dispute that must be resolved by a jury at trial, not by the court on summary judgment. Next is the liberal construction standard, and this applies to pro se plaintiffs. It says that the court has to interpret our filings liberally, and basically they have to hold us to a less strict standard than filings by attorneys. Now, this comes from the case of Haynes versus Kerner, which says the allegations of a pro se complainant must be held to less stringent standards than formal pleadings drafted by lawyers. So if our employer does something like try to have our opposition thrown out over something simple like a formatting issue, we can cite Haynes and argue that that shouldn't cost us our day in court. Although plaintiff's opposition may contain formatting errors, courts must construe pro se filings liberally and not penalize procedural mistakes, as established in Haynes versus Kerner. Next, we want to be familiar with the McDonald-Douglas burden-shifting framework. which isn't a standard per se, but does apply to all discrimination cases and retaliation cases, regardless of what stage of the process we're at. First, we have to establish our prima facie case, and that means we have to show some basic facts that show the discrimination could have occurred. And once we do that, our employer can offer a legitimate, non-discriminatory reason for whatever they did. And once they've stated their reasons, we can refute them by showing evidence that the reasons they gave are pretext. This framework was established in the case of McDonald Douglas Corporation versus Green, and it's been reinforced in Reeves versus Sanderson Plumbing Products. A plaintiff's prima facie case, combined with sufficient evidence to find the employer's justification false, may permit the trier of fact to conclude that the employer unlawfully discriminated. So if we have evidence of pretext, we want to cite to it in our exhibits and then cite Reeves, which says that at trial, a jury could find in our favor on the basis of that evidence of pretext. And that means summary judgment isn't appropriate. Plaintiff has submitted evidence showing contradictions in defendant's stated reasons for termination and differential treatment of similarly situated employees outside the protected class, which creates a genuine issue of pretext for trial. And under Reeves, such evidence may allow a reasonable jury to find that the defendant's explanation is a pretext for discrimination and find in favor of the plaintiff. Now, another important rule at summary judgment is that we don't have to prove our whole case here. We just have to show enough evidence to convince our judge that a reasonable jury could find in our favor at trial. And this, too, comes from both Anderson and Reeves. When considering a motion for summary judgment, the court should determine whether the plaintiff could satisfy his prima facie case and whether the plaintiff has produced sufficient evidence for a reasonable jury to reject the employer's non-discriminatory explanation. So if we have evidence suggesting that our employer might have discriminatory intent, for example, even if our evidence isn't a smoking gun, we can still cite to it in the exhibits and use Anderson and Reeves to argue that at trial, that evidence could be enough to convince a jury to find in our favor. Plaintiff's emails suggesting discriminatory intent, Exhibit 7, while circumstantial, create a genuine issue of material fact that must be resolved by a jury. Now, whenever we cite a piece of evidence in our opposition, we also want to tie that to a legal standard and explain how it's material to our case and why summary judgment is improper. Consistently connecting our evidence to the case law in this way shows our judge that we understand the rules around summary judgment, and we understand that every argument we make in our opposition has to be supported by evidence and by case law. And that's going to go a long way toward making sure that our judge gives our opposition fair consideration. So that's it for today, guys. I'll see you next time. Meanwhile, take care and hang